Resuming debate. Order. Order. I invite members to take their conversations into the lobbies. Order. Resuming debate. The honourable member for Nanaimo Ladysmith.
Thank you, Mr. Speaker. I rise today to speak in support of Bill 246, proposed to ensure laws prevent animal cruelty, shark finning, and the sale of products made from pet fur. Because Canada's law on offences against animals have not been substantively changed since 1892, constituents such as Robin Frew and Judy Davidic of Nanaimo are urging me to, quote, move mountains against animal cruelty. Large sections of this bill advance measures that New Democrats have proposed over time, and we would like to see these become law. And we'd like to see the hard work of many community organizations and parliamentarians of all stripes recognized. Most important to say up front, this is about animal abuse, not animal use. This bill would not apply to lawful activities such as hunting and fishing. The Department of Justice has been clear. This bill applies to criminal abuse, not lawful activities involving animals. But because letter writers have conveyed to me that they fear the lawful activities of ordinary Canadians could be interpreted as being affected by this bill, we will introduce amendments to clarify that. The NDP wishes to protect the right to hunt, fish, farm, and trap legally, and we will propose amendments to clarify that. Hunters and anglers are vital conservation partners on Vancouver Island, and we need them to be part of the conversation about criminal animal cruelty. So, the first part is about shark finning. Despite action by local governments to ban shark finning, Canada still imports several 100,000 pounds of shark fin every year, and this section of the bill would stop the importation of shark fins. Thanks to the New Democrat member for Port Moody Coquitlam, this measure came within 5 votes of passing in 2013. The only party that stood against it was the Conservatives, even though 81% of Canadians polled supported a shark fin ban at that time. One of the most comprehensive studies on shark fisheries was compiled recently at Dalhousie University in Halifax. In it, scientists estimated that at least 100 million sharks are killed every year around the world, maybe 273 million each year. And it found shark populations being depleted faster than they could reproduce. This threatens the stability of marine ecosystems around the world. The largest culprit is the illegal shark fin harvest, which shows a growing demand for shark fin soup. Sharks are hooked out of the ocean onto boats while their fins are sliced off while they are still alive. The rest of the shark is discarded back into the ocean, where unable to swim without their fins, they sink helplessly to the bottom to die. This powerful image was conveyed in shark water. It was horrific carnage that I will not forget. Now, while sharks have survived Earth's mass extinctions for over 400 million years, many shark species could be extinct within decades. A major environmental issue associated with shark finning is that the harvest is not specific to gender, size, or species. So we can't target harvests to avoid endangered species as we do with conservation-oriented fisheries. Now, further biological complication is that sharks are naturally slow to breed and mature. This makes sharks particularly vulnerable to overfishing, and it makes extinction for many shark species increasingly likely. And this is why extinction would be absolutely terrible. Shark extinctions would significantly alter ocean ecosystems, and they likely already have, because sharks are vitally important apex predators. Like wolves and lions, their terrestrial counterparts, top predators control the population of grazers below them in the food chain. If left unchecked, this can destabilize entire ecosystems. Now, specifically, sharks reduce the overconsumption and depletion of plankton by herbivorous fish. This is relevant to the pressing issue of climate change because plankton are a carbon sink. Plankton absorb carbon, and when plankton die, they sink the carbon to the bottom of the ocean where it sits. Without sharks, plankton populations will become depleted, meaning more acidic oceans, more carbon in the atmosphere. Shark extinctions will exacerbate climate change. The health of the oceans, the climate of the planet, and ultimately the survival of our species might depend on sharks. And if you, by any chance, you still believe the myth that sharks are bloodthirsty human eaters and ruthless killers that might actually harm our species, I will share this compelling stat with you. More people are killed each year by falling vending machines than are killed by shark attack. So please come together and please support the ban on shark fin imports for all our sake. Now, the second section of this bill, the provisions proposed to strengthen and modernize existing animal cruelty offences, they've been advanced by many members of Parliament, including former New Democrat Peggy Nash. They passed third reading in this House several times, and once they were even approved in the Senate. These changes are needed. For example, a man was acquitted of beating his dog to death with a baseball bat, but he was acquitted because the dog died quickly. Another example, for domestic animals, willful neglect has been hard to prove. Now, this bill that we're looking at today instead proposes a gross negligence offence for failing to provide adequate care, and where the individual is found to depart markedly from the standard of care that a reasonable person would use. And finally, the courts in this bill would be allowed to impose a lifetime ownership ban on repeat offenders of animal cruelty. 92% of Canadians polled support updating the criminal code to make it easier to secure convictions for animal cruelty offences, and I hope parliamentarians will stand with those people. The final section of this bill is to ban the sale of cat and dog fur, and also to require source labeling for fur. This would match the law in the US and in the European Union. Now, a 2012 Toronto Star investigation revealed that cat and dog fur is used in children's toys, boots, trim on coats. 3 NDP MPs have previously attempted the measures contained in this bill to ban the sale of that fur and to require source labeling for cat and dog fur. So in conclusion, I want to say again, this bill is not about hunting and fishing. If it was, I wouldn't support it. This is about animal abuse, not animal use. The bill applies to criminal abuse, not to lawful activities involving animals. And my riding is built on commercial fisheries. It's full of hunters and anglers doing vital preservation work. And our riding is very dependent on recreational and sport fisheries. Because I don't want anyone to fear that the lawful activities like those would ever be affected by this bill, this is an amendment that we will propose in committee to clarify that this does not affect lawful hunting and fishing. Finally, Robert Broadgill of Ladysmith reminded me of Gandhi's words: "The greatness of a nation and its moral progress can be judged by the way its animals are treated." I urge this Parliament to vote together and show leadership to end animal cruelty in Canada. Thank you.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Immigration.
Thank you, Mr. Speaker. I'm proud today to rise as the Member of Parliament for Parkdale High Park and speak on behalf of my constituents in support of Bill C-246, legislation that would strengthen animal protection in Canada. And I want to start with a now familiar quote, Mr. Speaker. "The greatness of a nation and its moral progress can be judged by the way its animals are treated." That's Mahatma Gandhi, Mr. Speaker. His words, uttered over half a century ago, remain as relevant today as ever. I say that because the last time animal cruelty laws were substantially changed in Canada was 1892. Mr. Speaker, that's the first year Lord Stanley's Cup was competed for by hockey teams in the Dominion. That was 124 years ago. Legislative change in this area is long overdue, and I applaud the member from Beaches East York for introducing legislation that would help bring Canada's animal protection laws into the 20th century. Mr. Speaker, before I even read Bill C-246, I heard about it. I heard about it from the engaged residents of my riding of Parkdale High Park, by mail, by phone, through email. I'm moved by the passion and dedication of my constituents, People like Ms. Barbie Lazarus and Mr. Kirti Shah from the Toronto Vegetarian Association, who have been advocating for fairer animal treatment practices in our community and around the country for years. Mr. Shah shares the same faith as my wife, Jainism, a religion which teaches about nonviolence and respect for all living things. They understand that the kinds of practices Bill C-246 will prohibit have no place in Canadian society. But I did not simply hear from adult advocates, Mr. Speaker. In my riding, I also heard from youth. On a visit to the class of Mr. Davis Mirza at Keele Street Junior Public School, I heard from grade 5 and 6 students about their concerns. They were shocked to learn how long it had been since changes were made to Canada's laws respecting animals, and they demanded that we, as parliamentarians, do better to ensure that our laws reflect the values of all Canadians, including our young people, who care deeply about animal welfare. Mr. Speaker, I've listened to the concerns of my constituents, and I'm committed to do better by supporting this important bill, which I seconded on May 9th of this year. But, Mr. Speaker, it's not just the people in Parkdale High Park that are concerned about animal welfare. Canadians across the country and across the political spectrum care deeply about this issue. A key indicator of this are a few facts. 5,630 people have been signed a petition, E509, in support of Bill C-246. 13,000 Canadians signed an e-petition number 123 relating to the use of cat and dog fur. And on change.org, 48,000 signatures were collected in support of this bill. So let's turn to the bill, Mr. Speaker. Bill C-246 addresses issues that I consider, to be frank, largely uncontroversial. First, it will ban the sale of cat and dog fur in Canada and require labeling which shows the source of all fur. Amazingly, Mr. Speaker, in this country we do not have labeling requirements for animal fur garments. As I have learned through the advocacy of residents in my community like Josie Candito, a tireless champion of animal rights in Parkdale High Park, cat and dog fur is used for trim on coats, the lining in children's boots, and the exterior of toys. This is all permitted to occur because we don't have the necessary prohibitions in place. Bill C-246 would change this. Second, Mr. Speaker, Bill C-246 will ban the importation of shark fins. I venture to guess that most Canadians are unaware about what actual shark finning involves. So let me explain it briefly, Mr. Speaker. Shark finning is the practice of catching a shark, cutting off its fin, and simply discarding the remainder of the shark's body back into the ocean. The still live, finless shark is completely unable to swim, sinks to the bottom of the ocean, Mr. Speaker, and drowns. Mr. Speaker, this heinous practice has been illegal in Canada since 1994, but the importation of shark fins continues unabated.
318,000 of shark fins were imported to Canada in 2015 alone. Municipalities like Calgary and Toronto have passed bans on shark fins, but those bans were overturned by the courts because they weren't within municipal jurisdiction. The courts held that the power to create such a ban on imports is federal. And that's a clear call on this Parliament to take action.
In relation to the bill, Mr. Speaker, Bill C-246 also answers the Supreme Court's call for clarity on the issue of bestiality. Allow me to explain. In the case of DLW, our Supreme Court acquitted a man accused of bestiality, where the sexual conduct involved a dog and the man's teenage stepdaughter. Because the act in question involved a disturbing act of oral sex and not physical penetration, Mr. Speaker, the Supreme Court of Canada overturned the man's conviction. In his majority ruling, Justice Cromwell said, and I'm quoting, "The term bestiality has a well-established legal meaning and refers to sexual intercourse between a human and an animal. It is manifestly not the role of the courts to expand that definition. Any expansion of criminal liability for this offence is within Parliament's exclusive domain." Mr. Speaker, as you can imagine, public response to this decision was incredulous, not because of the judge's interpretation. Justice Cromwell was simply applying the law, but because the actual definition of bestiality was so narrow. You don't need to be a lawyer, Mr. Speaker. You just need to apply some common sense to recognize that bestiality prohibitions ought to prevent all sexual acts with animals that are exploitative. Whether penetration occurs or not is not the issue and should not be determinative. That's exactly what this bill will address, Mr. Speaker, a legal void. It will expand the definition of bestiality, as the Supreme Court invited this Parliament to do, to cover, quote, all sexual activity between a person and an animal. This will improve on an important goal, preventing the sexual exploitation of animals in all of its forms, a goal which I'm confident all members of this House believe in pursuing. Fourth, Mr. Speaker, I'd like to address some misunderstandings about this bill. Bill C-246 is geared towards preventing animal abuse. It does not affect or prohibit legitimate animal use. So in the latter category, the rights of anglers and hunters are not compromised by this bill, nor are the rights of livestock farmers. Concerns about the impact of this bill on legal accepted practices is unfounded. Allow me to explain. To contemplate a situation where police, conservation officers, and prosecutors across this country would somehow investigate and begin charging and prosecuting hunters, anglers, or farmers engaged in well-accepted animal practices is simply not credible. As a former Crown Counsel who practiced law for 14 years, I know firsthand that police and prosecutors are far too preoccupied by serious criminals to use their precious limited resources to chase after our important farmers and law-abiding anglers and hunters. Legitimate, well-accepted animal use practices are not the target of this legislation. The target is animal abuse. And let me provide some examples, Mr. Speaker. Dogfighting. That's not simply a foreign problem. It has reared its ugly head recently in Tilbury East Township in Ontario, where they seized 31 pit bull dogs in a case involving 5 different individuals. Another example of animal abuse is puppy mills, Mr. Speaker. One such mill was discovered in Windsor this past June. A total of 14 dogs were found in the possession of a single woman, and the dog's physical condition had seriously deteriorated. One of the dogs, a Shih Tzu, Mr. Speaker, was found with 6 pounds of dried feces attached to its long matted fur. Those are the types of abuse that are targeted by this bill. The proposed amendments in this legislation to the animal cruelty provisions of the Code would facilitate prosecutions of abusers, moving the criminal standard from willful neglect to gross or severe negligence. In addition, this bill will close some of the loopholes that currently exist regarding animal fighting, those who benefit economically from it. This includes criminalizing receiving money for fighting animals and breeding, training, or transporting an animal in order to fight another one. The fifth point that I wanted to make, Mr. Speaker, is that Bill C-246 is based on sound evidence. There are numerous studies and journal articles which demonstrate that animal abuse is often a precursor to later and more serious criminal activity, including domestic violence. So there's an important public interest in enacting legislation that targets animal abuse and works to deter such behavior. This observation was made in previous submissions on this, on previous speeches on this legislation. By enacting Bill C-246, this Parliament can deter animal abuse, which has a derivative effect of helping to address some of the root causes of violent crime in this country, including violence against women. But I would urge, finally, Mr. Speaker, members of this House to get behind Bill C-246, not simply because it's based on sound evidence, but also because it's ethically sound. To circle back to the quote from Gandhi that I mentioned at the outset, you can judge a nation's moral progress by the way its animals are treated. This observation rings true because more so than any other unempowered group, animals are truly voiceless, Mr. Speaker. They cannot advocate for themselves. By definition, they require others to take up their cause. In 2016, some 124 years since the last significant change to animal cruelty provisions in the Code, I believe it's high time we took up that call as parliamentarians. That's why I'm supporting this bill. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Bruce Grey, Owen Sound.
Well, thank you very much, Mr. Speaker. I'm pleased to rise in the House today to speak to Bill C-246, the Modernizing Animal Protections Act. And I want to start out, Mr. Speaker, by saying that before my life in this place, I was a full-time beef farmer. And I can tell you that myself and all the farmers that I know out there who are livestock farmers, they all have pets as well, dogs. I was no different. Nobody has more respect for animals than those people. And so, Mr. Speaker, I am speaking not just for myself today as a parliamentarian, but and not just the farmers in my riding of Bruce Grey, Owen Sound, but for farmers everywhere, and also people who hunt, fish, trap. This is a bill that has them very concerned. So C-246, Mr. Speaker, is a reincarnation or reiteration of several other pieces of similar legislation that have come before this House over the years. And having been a member of Parliament since 2004, I can say that I've seen some variation of this bill in almost every Parliament that I've been a part of. It has been voted down every single time due to concerns that it goes too far and endangers legitimate animal use. And I will express these same concerns here today. The riding that I represent, Mr. Speaker, is a rural riding that's home to a lot of farmers, hunters, anglers, and trappers. And for constituents of Bruce Grey Owen Sound, animal use has always been a vital part of their everyday life. And for this reason, I will be speaking against the passage of Bill C-246 at second reading, as I feel that it would endanger the livelihood of many residents of Bruce Grey Owen Sound and across Canada, and possibly put an end to a number of farming, hunting, angling, and trapping traditions across Canada. I'd like to start by stating that I am fully supportive of legislation and initiatives that seek to promote better welfare for animals, and am full support of harsher penalties for those who willfully and intentionally do cruelty to animals. Now, I think, Mr. Speaker, that those who are knowingly cruel to animals, they should face the full force of the law. Nobody disputing that, and anybody that's opposed to this bill doesn't dispute that aspect of it. But in fact, last Parliament, I was pleased to vote in favour of Quanto's Law, which was a piece of legislation that enhanced legal protections for service animals of police agencies and the Canadian Armed Forces. Furthermore, I note that the bill contains provisions surrounding shark finning, which again, I am opposed to, but shark finning has been illegal in Canada since 1994. We shouldn't even be talking about it. There is no need. It's illegal already. Overall, Canada has very good animal welfare legislation at both the provincial and federal levels, but I am always open to discussing potential problem areas to ensure that animal welfare is upheld. These are not the measures that I have great concerns with, though, Mr. Speaker. When it comes to C-246, I'm specifically concerned with 4 specific sections of the bill. The first is a section of the bill that moves the provisions in the criminal code surrounding animal cruelty out of the section dealing with offences against certain property and moves this to the section dealing with offences against persons. This could be the start of a very dangerous trend. Essentially, moving animal cruelty provisions to the section of the criminal code this section of the criminal code begins to suggest that animals are entitled to the full rights of human beings and have the right to be represented in court. And I find this deeply troubling, as it could be the beginning of the end of hunting, farming, angling, and trapping. And, you know, Mr. Speaker, to put this in perspective, it doesn't mean, to not put them on the same grounds that we don't respect animals. But I'll tell you, if I got to, choose one of my family, one of my grandkids, or between that and my dog, as far as the same rights, I think there's only one obvious way that you're gonna choose, and I hope I never have to come for that. But this bill could do that. Furthermore, C-246 contains a number of new provisions that redefine what constitutes criminal activities against animals. The first of which is the inclusion of a recklessly test that would be included alongside the willfully test. What this means is that willfully causing harm or suffering to an animal that has always been illegal. But this bill would add a new host of actions that would fall under the test of recklessly causing harm or suffering. The problem here is that it is not clearly defined as to what constitutes the recklessness. Would hitting an animal with your car constitute reckless harm or suffering? We've all hit animals, or most of us have, if you drive in rural Canada. So would hitting an animal, cause this reckless harm or suffering? I don't think so. It's not intentional, but accidents happen. These are the loopholes that make this bill so dangerous. I would not want to see anyone slapped with a criminal record for hitting a coon or a deer, whatever, with their car. Now, my greatest concern is with the following provision, which I will read here. Under section 182.2, subsection 1, that everyone commits an offense who willfully or recklessly kills an animal, or being the owner permits an animal to be killed brutally or viciously, regardless of whether the animal dies immediately. To me, this opens up a very serious can of worms that would result in the criminalization of farming, hunting, angling, and trapping in Canada. The words brutally and viciously are used here to describe what could constitute an offense against animals under the criminal code. A major problem here is that there is no definition, again, of what is meant by brutally or viciously. Furthermore, these terms are completely brand new to any sort of legislation related to animal cruelty here in Canada, in the United Kingdom, in Australia, and in the U.S. Further still, no Canadian court has ever interpreted this language, so we don't know how this will play out once this legislation comes into force. I have heard from a great number of constituents and stakeholder groups that this has the potential to criminalize any sort of animal use in Canada. The language is simply too vague. It's unacceptable. For example, Mr. Speaker, the group PETA states that animals are not ours to kill, eat, wear, experiment upon, or exploit for entertainment. Now, for me, it would seem as though PETA would certainly claim that slaughtering cattle for beef production would constitute a brutal or vicious act against animals. There goes our agriculture industry. They would most certainly state that shooting a deer, moose, turkey, you name it, it would be a brutal or vicious act against animals. There goes recreational hunting in Canada. A fish with a lure in its mouth, gone is the recreational fishery. A muskrat or beaver in a trap, there goes our trapping and fur trade. I think you see the point that I'm trying to make here, Mr. Speaker. Because the provisions in this bill are so open to interpretation, and because the interpretations out there are so wide-sweeping, we could see the end of many different traditions and practices related to animal use in Canada. While I do not think that it was the intent of the sponsor of the bill to criminalize these activities, it is most certainly a major problem of the legislation. Furthermore, a simple solution would have been to clearly state a list of activities that are exempt from the provisions in the legislation. This list should include ranching, farming, hunting, fishing, trapping, and medical research. This would ensure that these legal activities would not result in the handling out of criminal records for otherwise lawful activities. And finally, Mr. Speaker, I want to discuss the host of proposed changes that have been sent to me by the sponsor and that many stakeholders have been talking about. I do appreciate the efforts made by the sponsor to enhance the bill and respond to concerns from the farming, hunting, angling, and trapping communities. However, there's no guarantee that these amendments will be proposed and adopted by the committee. Therefore, at second reading, as the bill is currently drafted, I cannot support it. I did take some interest from what my colleague, the Parliamentary Secretary to the Minister of Justice, said when he spoke to this bill at the first hour of second reading. He stated, "Animal cruelty is an important social issue that deserves a comprehensive legislative response. It needs broad public consultation to allow us to get this right. The best way forward is in the review of the criminal code that will take place in the future. This way we can hear and attempt to address the concerns of Canadians engaged in legitimate activities of hunting, fishing, ranching, medical research, etc." While I do not always agree with my honourable colleague on all issues, on this issue he has hit the nail right on the head. We need to consult with those who have expressed concerns about the bill so that we can ensure that we protect animal welfare in Canada in a way that does not criminalize traditions that rely on animal use. And in closing, I know I'm almost out of time, Mr. Speaker, I'd like to say to the member, I truly do, that he tried to fix this after the fact. But he could have drafted this bill with the right kind of consultation in advance. I'd be happy to work with him on something like that, and I think there's probably other members of my caucus. So in fact, I know there is that would work, but we just cannot support it in the way it is. Thank you very much.
Resuming debate, the honourable member for South Okanagan, West Kootenay.
Well, thank you, Mr. Speaker. I appreciate the opportunity to speak to Bill C-246 today, and I thank the member from Beaches East York for bringing it forward. It deals with three rather loosely related issues: animal cruelty, the importation of dog and cat fur, and shark finning. I've received a lot of feedback on this bill from constituents, most of it in favour of the bill because it seeks to strengthen animal cruelty law, but I've also heard a serious concern from outdoors enthusiasts who felt that the bill might have inadvertently caught up hunting, fishing, and trapping in the web of animal cruelty provisions. I've had meetings with 3 hunters groups in my riding who expressed this concern clearly. I assured them then, and I assured them again, that this is certainly not the case, and if it were, I could not support it. That said, I would be happy that if the committee would explore amendments that would make that crystal clear and perhaps list the legal activities that were excluded, as the previous member stated. But this is really about criminal cruelty, not legal hunting, fishing, trapping, or agriculture. Now, I'd like to spend the rest of my time talking about the third issue dealt with in this bill, and that is shark finning. Finning is the practice of removing fins from live sharks on board fishing boats and tossing the big animals overboard where they die a cruel death. So in that sense, finning might belong in this bill about animal cruelty, but it's really the impact on shark populations and how that changes our ocean ecosystems that I think is a deeper concern. Mr. Speaker, many Canadians might not know how widespread, important, and diverse sharks are in Canadian waters. There are 28 species of sharks off our shores, most of them large predators. Some are at the top of the food chain and play a key role in shaping our marine ecosystems. Like many large predators, they're slow-growing, slow to mature, slow to reproduce. These are all features that make their populations very sensitive to overharvest, especially the overharvest of adults. And sharks have been suffering serious population declines in recent decades for a variety of reasons. Of the 245 species of sharks in the world, 65, more than a quarter, are on the red list compiled by the International Union for Conservation of Nature. They're at some real risk of extinction. The Committee on the Status of Endangered Wildlife in Canada, CIWIC, has assessed 6 species of Canadian sharks and listed 3 as endangered and 3 as species of special concern. The 2 main causes of population declines are fisheries bycatch and shark finning. And these 2 issues are related, since many sharks caught in other fisheries, such as the longline fisheries for tuna and swordfish, are routinely finned and tossed back. Estimates of the numbers of sharks finned each year are difficult to calculate, but all estimates are mind-bogglingly high. 100 million is the standard answer, but some estimates are over twice that. This practice is changing our oceans forever. Can you imagine 100 million bears disappearing from our forests each year and what that would do to our ecosystems? Or what about the loss of 100 million lions from the plains of Africa? Some species are particularly hard hit by finning. The scalloped hammerhead has declined by over 90%. One study suggests a loss of 98% over a period of 30 years off the east coast of North America. Data from the same coast indicate that the population of oceanic white-tip shark, once one of the most abundant large animal species in the world's oceans, declined by over 70% between 1992 and 2000. So that's 70% in only 8 years. This species is rapidly becoming functionally extinct. So I heartily support this bill and its effort to curb the trade in shark fins. It's a good first step, an essential first step, but Canada could and should be doing more on both the national and international stages to make an impact here. The government has spent a lot of effort to get the message out that Canada's back on the world environmental scene, but we are sorely lagging in many aspects of global environmental action. For example, we could be cooperating with other nations in the International Commission on the Conservation of Atlantic Tuna, who have been calling for meaningful bycatch limits for sharks during the tuna fishery. But both Canada and Japan have been dragging their feet on this issue. We could take the bold step to promote the listing of all shark species on Appendix 2 of CITES so that the international trade in shark fins can be better regulated. And in our own backyard, Canada needs to reinvest in fisheries science and monitoring. Setting regulations about bycatch and creating laws about shark finning will accomplish little if there's not a significant government presence on our coasts to actually witness what is happening to our oceans. And we could put more emphasis on science when government receives listing recommendations from CIWIC. CIWIC makes annual recommendations on species to add to the species at risk schedules, and government then decides whether to act or not. Bird species are almost always added as a matter of course. But fish species only have a 50-50 chance of being listed because economics often trumps the science of endangerment. We must rebalance this policy to ensure that our ocean ecosystems remain healthy into the future. So in closing, Mr. Speaker, I reiterate that I will support this bill. It's about criminal acts of cruelty, not legal hunting, fishing, and trapping agriculture. And I support it both for its strengthening of the animal cruelty law and for its steps to support the conservation of sharks. Thank you.
Reprise du débat, l'honorable député.
Resuming debate, the honourable member for Laurentides-Labelle.
Mr. Speaker, I take no pleasure in rising today on Bill C-246. Je suis d'abord et avant tout un député.
I am first and foremost a rural MP. I was born in Sainte-Agathe-des-Monts and I grew up in Sainte-Lucie-des-Laurentides. At home, we grew most of our food, including vegetables and meats. We are a farm participating in the WOOF program, an international program for workers on organic farms, volunteer workers. I've got a fishing license. My father has a hunting license. We raise chickens, ducks, geese, and a lot of game. In October, a large part of my riding heads out to hunt deer and moose, and effectively the year is divided into 2 hunting seasons for each animal. And at all times, agriculture producers prepare their animals for slaughter to sell their meat to feed the cities. So that's what life is like for us on a daily basis in the regions.
Or to hunt, trap, and fish wild animals. The world population of chickens, as an example, exceeds the world population of humans by a factor of about 7 to 1. And while there are legitimate reasons to work with animals, there are people who abuse them. For example, worldwide problems such as puppy mills, the wanton waste of shark finning without using the rest of the animal, poaching of elephants and rhinoceros for their ivory, allowing animals to fight, killing animals purely for sport, or slaughtering them in torturous and unethical ways are all places the great majority of us would agree improvements must be made. But that is not, despite the appearance of the social media pressure, the goal of Bill C-246. The bill, as written, and as is before us here at second reading, is not a moderate bill looking to tangibly and positively improve animal welfare. It is an overreaching bill by a passionate advocate whose incredible work on this file I deeply respect, even if I do not agree. There are few members of this place ever to have put their heart and soul into a cause they believe in as completely and selflessly as the member for Beaches East York. I think we all respect and appreciate that. But that is not what is before us. But what is before us is not a bill. Is not a person. And the effect of the bill is to risk criminalizing currently legal animal activity. Mr. Speaker, I don't believe that my family belongs in prison for sustainably feeding ourselves. I don't believe tens of thousands of my constituents should be risk prison for feeding their families either. We are reassured in supporting statements that the bill has no effect on current legal activity. But the only reassurance we have is the statements of those supporting the bill. The language of the bill itself is not so ambiguous. Section 182.1 sub 1 sub b reads, for example, everyone commits an offense who, willfully or recklessly, kills an animal or, being the owner, permits an animal to be killed brutally or viciously, regardless of whether the animal dies immediately. It is easy to argue that because killing an animal necessarily results in its death, the act is inherently brutal or vicious. Bringing a legal case against anyone who kills any animal in any circumstances is therefore enabled by this act. There is no exception for aquaculture, agriculture, hunting, fishing, or even accidents, and the instantaneous death of the animal is explicitly removed as a factor for consideration. To add insult to injury, the Criminal Code section 429 sub 2 currently reads, no person shall be convicted of an offense under sections 430 to 446 where he proves that he acted with legal justification or excuse and with color of right. While C-246 fixes the gender-specific references to be gender neutral, it also removes the justification defense from sections 444 to 446 of the Criminal Code, which is the section that currently deals with animal welfare. The penalty is set at up to $10,000 or 5 years in a federal penitentiary, and regardless of the probability of conviction, the case needed to bring some of these situations to trial would be established by this open-ended bill. A federal penitentiary is no laughing matter. There is one in my riding at the former Cold War missile base, La Mikaza. I toured that facility this summer, and I do not wish to return there as a result of my fall harvest. Now, we are assured by proponents of the bill that the legal system would not tie itself up in these legal cases. This letter I received in my office, for example, reads in part, the Canadian Sport Fishing Industry Association's claims about how Bill C-246 would impact fishing are ludicrous. They state that even the act of baiting a hook with a worm would be considered an act of cruelty according to the bill. The MP for Beaches East York and law professor Peter Sankoff contend that such claims about the effects Bill C-246 would have are preposterous. Can anyone imagine Canada's criminal justice system wasting time and resources to attempt to prosecute someone over such a ridiculous allegation? Yes, Mr. Speaker, I can imagine that, because were C-246 to receive royal assent, as it is written, a law telling police and prosecutors to do exactly that would be on the books, having been placed there after thorough examination by a majority of parliamentarians, and remaining there until one or several judges, being faced with such a ridiculous allegation in the courtroom, struck down that law. Moreover, the bill contradicts its proponents on this very point. It creates section 182.5, which states, and I quote, "For greater certainty, nothing in this part shall be considered so as to abrogate or derogate from the protection provided for existing Aboriginal or treaty rights of the Aboriginal people of Canada by the recognition and affirmation of those rights in section 35 of the Constitution Act 1982. If the bill does not risk creative new application, why would it need an exemption?" So it begs the question, what purpose is a law whose authors do not wish for it to be enforced? Why go through the trouble of authoring and presenting a bill if the hope is that the justice system will ultimately ignore or reinterpret it? Mr. Speaker, if the desire of the drafters of this legislation is to ensure that existing, accepted, or common practice not be affected by this bill, why does it not state that? These proponents tell us that it will have no such effect. But, Mr. Speaker, in case of disagreement between speeches in Parliament and the text of the resulting Act, it is the text of the Act that will form the basis of the criminal case. Nobody here is against stopping the genuine abuse or mistreatment of animals in any circumstances. But my job here is also to protect the people who work with animals, who live with them, who take care of them and live by them, and who feed the rest of us. Mr. Speaker, I want to highlight the good work of the National Farm Animal Care Council, which consists of farmers, processors, the National Veterinary Association, National Animal Welfare Associations, provincial farm animal care councils, and so on. They work on a collaborative basis to enhance codes and practices on our farms, but they also adhere to core values, which are: they accept the use of farm animals in agriculture, they believe that animals should be treated humanely, and they support approaches that are scientifically informed. Mr. Speaker, that is the way we work to improve animal welfare in Canada. Unfortunately, Bill C-246 could undo the good work of those organizations by unfairly targeting them through the legal system. Mr. Speaker, we have been told that this bill will be modified at committee to address the many concerns that have been raised, of which I have only barely scratched the surface here today. This presupposes the outcome of the committee hearing. Committees, as you know, Mr. Speaker, are their own masters. To modify the substance of the bill, the unanimous consent of this chamber is required. We saw that this is not achievable. Procedurally, at committee, a bill cannot simply be redrawn. Amendments may be proposed by members, but are up to the committee to adopt or reject. Significant changes are not in order, and the chair of the committee and the Speaker of the House have a responsibility, a duty deeply established in a parliamentary convention, to rule changes beyond the scope of a bill out of order. To get it to committee, the House must agree with it in principle. To change it, the committee must keep it within that principle. For me to vote for this bill here now at second reading, I must agree with the text as it is written in principle. Mr. Speaker, I do not believe that hunters, fishermen, trappers, farmers, homesteaders, and others working with animals belong in prison. I do not agree with this bill in principle, and I hope, Mr. Speaker, that my colleagues will have the wisdom and the foresight, too, to reject this bill, to kill it without further pain or suffering. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Prince George, Peace River, Northern Rockies.
Thank you, Mr. Speaker. And I just want to commend my colleague across the way for a great speech. And we have a lot in common on the other side. As co-chair of the Parliamentary Outdoor Caucus, I share that role with a fellow Liberal from Newfoundland and Labrador. So sometimes these issues cross party lines, and we're supportive of each other across the aisle even as well. And I just want to commend him again for that particular speech. I have three concerns with this particular bill, Mr. Speaker. It potentially criminalizes traditional practices of hunting, trapping, angling and fishing and farming. Two, it changes the definition of animals from property to people. Three, we already have extensive animal rights laws protections in Canada. I'll start with the first. I think most of us have gone fishing with parents, family, likewise hunting. A lot of us in this place have backgrounds in farming and agriculture and have raised cattle to be harvested for either hamburgers or steak or whatever, what have you. And certainly I think the first group, as was mentioned by my colleague on this side of the House, was that the last people that would want to be cruel to an animal, I think, are groups that actually know these animals and that see these animals every day. like farmers, hunters, and fishermen and anglers. To potentially put these particular groups of individuals into a place where they can be accused of being criminal, to us is definitely too far-reaching for us to accept this particular bill. A key change in what the bill actually proposes, the new kill an animal offense, and I'll read it out before the chamber tonight. 182.21, everyone that commits an offense who willfully or recklessly kills an animal or being the owner permits an animal to be killed brutally or viciously, regardless of whether the animal dies immediately. Further, it goes on, C, kills an animal without lawful excuse. Concern there, Mr. Speaker, are the two words brutally or viciously. Certainly in this chamber of 330 plus individuals, brutally and viciously have different definitions and different meanings to most of us in this place. For one, brutally and viciously is understood as something that's done that's inhumane, that's affecting an animal in a negative way, with concern with the animal's sensibilities, I guess. But another one could be considered for the common practices of even catching a fish, for instance, where you have to, once you catch the fish, you have to do what you have to do to end its life, and so it can be consumed and eaten as a fillet for supper. That could be deemed brutally or viciously killed. And that's my concern, that we have groups of people that have traditionally fished, hunted, and trapped, etc., that will now be potentially accused of being brutally or viciously treating of animals. And I know the members across the way that or the member that's putting this forward says that's not the case. But the potential for that definition to be taken far and wide is what concerns a lot of us in this place. I'll talk to number 2 as well, just about the changing in definition from property to people. And the change is significant because it takes animal cruelty offenses out of the section dealing with offenses against certain property, Mr. Speaker, and moves to the section of criminal code dealing with offenses against persons. That's very important, that distinction, Mr. Speaker, because now instead of involving property, we have potential offenses against human-type individuals, which certainly puts it into a different level than the criminal code than I think most of us would be considered acceptable. Again, I want to get to the premise of what the honourable member that presented 246. Again, on this side, and I know many on that side too, don't want to see cruelty to animals. I have a family pet. We've had family pets in the past. We cherish them as members of our family. But to hold them as an equitable member of that family to the human beings in our family is too far in my mind. And I agree with my colleague as well that said that earlier. Lastly, we already have extensive legislation that deals with animal cruelty in Canada. And so to say that we need more legislation to make sure that this doesn't happen is just not necessary. And I thought it was interesting. I think one of the members that said they're going to support this particular case had talked about a certain case of animal cruelty where certain animals, or I think there were dogs, I believe that the member said, were abused. They were emaciated. They were down to a fraction of what their healthy weight should be. But they were acknowledged as being abused, and they were dealt with in the system. The owner was charged, and the court case went before the courts. Well, there's an example, Mr. Speaker, of the current laws in this place working, and it already is functional. It already functions well to already deal with animal abuses and cruelty. We don't need more laws on the books, Mr. Speaker, to go even further. I'll go into just a bit more about what our current laws are, because I think people out there that are watching us tonight may not know, may think that we need laws, but I'm going to state the laws that we actually do have, part of it. And the offenses, it's in Part 11 of the Criminal Code, titled Willful and Forbidden Acts in Respect to Certain Property. These are current laws on the books, Mr. Speaker. Section 4.4 5.1 states, everyone who commits an offense, A, willfully causes or being the owner willfully permits to be caused unnecessary pain, suffering, and injury to an animal or bird. Well, that's fairly comprehensive, Mr. Speaker, in dealing with animal abuse, in my mind. Other subsections are more specific. Sections 445 prohibits willfully and without lawful excuse, kills, maims, wounds, poisons, injures domestic dogs, birds, and animals. Section 446, causing damage or injury. By willful neglect, causes damage or injury to animals or birds while they are being driven or conveyed, or being the owner of or the person having the custody or control of a domestic animal or bird, or an animal or a bird wild by nature that is in captivity, abandons it in distress, or willfully neglects or fails to provide suitable and adequate food, water, shelter, and care for it. And I think, those are just a few parts of the laws that are already on the books that deal with animal cruelty. Although I applaud the member, I'll talk about this too, about shark finning. Shark finning is another one of those practices that's already on the books that can't be done in Canada legally. And if you're caught doing it, you'll be charged. Those are laws, Mr. Speaker, that are already on the books currently today. And so it's just my view, along with, as co-chair of the Parliamentary Outdoor Caucus, I guess I've really learned to appreciate this part of our Canadian heritage that, we started this place, not we, but our forefathers did. Hunting, sustenance, fishing was all part of what we did. Farming as well. It was all part of our tradition. Not just that, but it was necessary for survival. So to now come in with legislation that potentially criminalizes that historic activity unnecessarily, to us is an overreach. And again, I've gotten to know a lot of these folks that would be captured up in this type of legislation, myself included would be, because I fish and hunt. But I guess I've gotten to know this community quite well, and you can't ask for a bigger group that wants to help conservation. The conservation issues in Canada, proceed is this group. Ducks Unlimited's a group, many other groups that are supportive of conservation and do tireless work to see that animals are treated healthy, that they have places to grow and prosper, and to affect this group of really good folks that are well-meaning with possible charges of criminal activity, again, is more than we want to go. And again, I applaud the member for his intention. I know, again, like I said, my family appreciates our pets. We have an English bulldog. We lost our dog a year ago that died, and it was impactful to our family, I must say. But so we care about animals too, but we just think that 246 is too far. And Mr. Speaker, likewise, I'll be standing with my colleague on the Liberal side from Newfoundland and Labrador, my co-chair in the Parliamentary Outdoor Caucus, and we'll both be opposing this particular bill. Thank you.
Resuming debate. Reprise du débat. Seeing none, the honourable member for Beaches East York has 5 minutes to right to reply.
Thanks very much, Mr. Speaker. First, I want to say thank you. Thank you to Canadians across the country for caring, for speaking up for those without a voice, and for standing up for improved animal protections. My colleagues have been inundated with correspondence in support of C-246. I want to in particular thank Ruby's Love Letter Legacy, an organization come together to stop puppy mills, and animal cruelty legislation advocates, both grassroots organizations working to improve our animal protection laws. When I introduced this bill, I said Canadians from all parties support ending animal cruelty. I don't think this is a partisan issue. I don't think it should be a partisan issue. I would stand alongside farmers, like my in-laws. They would disown me, by the way, if I did anything to farmers. I stand alongside farmers, fishermen, anglers against animal cruelty, and certainly, as any number of our colleagues here today have said, this is about ending animal abuse, not ending animal use. When I introduced the bill, I said, this bill is to bring our laws into the 21st century. I overstated the case. This is a basket of modest measures, all things considered, to improve our animal protection laws. There's been a ton of confusion about the bill. Am I giving animals rights? The rights not to be tortured and abused, if we want to call those rights. So what does the bill do? The bill does three things. We've touched on some of them. So shark finning. Some folks in this House have said shark finning is already illegal. We don't have to worry about shark finning. The Globe and Mail reported that last year, 300,000 pounds, over 300,000 pounds of shark fins were imported into the country. When they're tested, commonly, they're found to be from endangered species. Other countries have bans on the importation of shark fins. 10 states in the U.S. have bans on the trade of shark fins. When we look at Australia, there's actually an international norm, a landed shark requirement. So the terrible practice is when they cut off the shark's fin and waste the body at sea. So what do countries do? They require that the shark be landed intact and then can be finned. If an amendment's required, I'm perfectly open to that idea, but we should in this House stand against the practice of shark finning, and not just within our borders. We don't have many sharks in the Canadian borders, against importing shark fins, I should say, into Canada. Fur labeling and banning the sale and importation of cat and dog fur. I don't know who could stand against who could stand in favor, I should say, of importing and selling cat and dog fur. There have been numerous petitions in this House against the practice. It's been banned in the EU and the US for years. Why Canada would lag in this area is beyond me. When we talk about fur labeling, again, the EU and the US require fur labeling. Big companies in Canada already do this. You buy a Canada Goose jacket, you see it comes from Coyote. Why all companies should not be subject to this practice as a matter of consumer choice is beyond me. Animal cruelty in the criminal code. You know, I've been accused of drafting this legislation and the wrong-headed way I drafted this legislation. This legislation was drafted in 1999 by the Justice Department. So the opinions that my opinion matters as to its effect, ignore my opinion. Take the opinion of the Justice Department that drafted it. Take the opinion of Honourable Anne McClellan. Take the opinion of Honourable Martin Cochon. Take the opinion of the Honourable Irwin Cotler, all of whom propose identical legislation. Or, if you don't trust them, take the opinion of the Cattlemen's Association, of the Dairy Farmers of Canada, who in 2004, among many other animal use organizations, wrote a letter to the Honourable Irwin Cotler to say, please pass this legislation. What legislation? The identical legislation that is before you with respect to these criminal code amendments. Now, I recognize we're over a decade later. People don't have the institutional memory. People are worried about this legislation. I listened, I consulted, I met with more agricultural sector groups in my tiny little office. I'm not the department, I'm not the ministry of anything, and yet we consulted broadly over the spring and over the summer. We heard concerns. And, you know, some people said they're political concerns, they're not policy concerns. I didn't particularly care. I'm pragmatic enough to know I want something to pass. I want to improve our animal protection laws. So I proposed amendments. I proposed amendments to limit the criminal code to 3 specific things. Amending bestiality to address the Supreme Court case. Expanding the definition of animal fighting. No one's going to complain about criminalizing profiting off of animal fighting, breeding, training animals for the purpose of fighting. And I limited the criminal code amendments, the third piece, to gross negligence. Why? Because every standard across the criminal code with respect to negligence is a gross negligence offense, a marked departure from the norm. Why would animal cruelty be any different? But right now it is the only standard in the criminal code that is willful neglect. That's it, these 3 changes. And as far as process goes, our job in this House is to support legislation if the object of the bill is something we can support at second reading. And guess what? If the changes aren't made at committee, and I'll be the first one to propose changes when I address the committee, but if these changes aren't made, the bill comes back to us at third reading and we can vote it down. And if these changes aren't made, I encourage all of you to vote it down. But if you don't vote in favor of it at second reading, I encourage you to tell your constituents you don't care about the object of the bill, which is ending animal cruelty. Thanks very much, Mr. Speaker.
La Chambre est-elle prête?
Is the House